Motu, tēnā koutou, tēnā koutou, tēnā koutou katoa. Ko ahu te komihana matatapu, ko Michael Webster aho, tēnā koutou katoa. I am Michael Webster, New Zealand's Privacy Commissioner, and I'd love to welcome you to this university. I do so having been discussing with Nicole, our lecturer tonight, our distinguished lecturer, that it is in no small fact due to this place where I studied political philosophy more years ago than I want to remember, that I am actually here as Privacy Commissioner. I was excited, energised, and fired up by discussions about rights during many lectures on political philosophy over a number of years. And that is, I guess, one of the things that we wish to acknowledge tonight about the role of Sir Bruce and the role that the academic community can play in carrying forward that discussion. So welcome, everyone. Thank you, Shane, my officer's Paul here, for your welcome. Thank you, Marcin, Chair of the Privacy Foundation, our partners in this event. Welcome to everybody here in Wellington, but also those who are our Zoom attendees. Thank you for joining us across New Zealand. As you may have heard, we are recording this session, but the focus obviously here will be on our speaker. The Sir Bruce Slane Memorial Lecture is a highlight of my office's event calendar, and especially meaningful in that it is, of course, named after New Zealand's first Privacy Commissioner. Sir Bruce played a pivotal part in the development of New Zealand's privacy law. He helped to shape it and subsequently achieved its successful implementation. He was, as many will know, a strong supporter of civil rights and upheld the rights of everyday, ordinary people to safeguard their personal information against unwarranted intrusion. And in what is, frankly, a fractious and fractured world right now, where all rights are being debated, defended, attacked, and encroached upon, never has it been more vital, I suggest, to talk about the value of rights, and tonight in particular, the right to privacy. Tonight, speaking in Sir Bruce's honour, we are lucky to have Professor Nicole Morum. Professor Morum teaches and researches on media law and the law of obligation with a particular focus on privacy. And tonight she will speak on the topic, balancing privacy and other interests in the social media age. I do wonder, Nicole, what Sir Bruce would have made of social media, and I'm very keen to hear what you have to say on this topic and how it relates to privacy. So please join me in welcoming Professor Nicole Morum to deliver the 2023 Sir Bruce Slane Memorial Lecture.
Thank you, Michael, and kia ora tātou. I was in the second year of university when Sir Bruce Slane became New Zealand's first Privacy Commissioner. And despite being in Canterbury and a long way from the machinations of Crown entities in Wellington, his name managed to reach my consciousness even down there. In fact, I still associate his name, with the public recognition, not just of the importance of the privacy interest, but also of the beginning of a time when we took protecting it seriously. He was hugely successful at that time in bringing privacy and the Office of the Privacy Commissioner into the public consciousness and into the government's consciousness at a very important time in privacy's development. Now, in doing this, as some of you might have seen as you came into the room, he had an advantage that would be the envy of any head of an organisation, and that is a son who's a very talented cartoonist. The Office of the Privacy Commissioner is without doubt the winner of the all-time greatest Christmas card prize. In fact, I've still got a whole lot of them tucked into my books. And they were all funny, but often also very poignant reminders of the importance of the privacy interest, which Sir Bruce spent so much of his career promoting. Now, as Michael just foreshadowed, both the means of interfering with privacy and its protection have come a huge way since Sir Bruce's time. It was not long ago that if he wanted to profile somebody or to discover their tastes or their shopping habits or their general interests, you had to run a census or do a survey, or maybe, shock horror, get to know them personally. And if you wanted to access a mass audience, then you had to have a printing press or a broadcasting license, or at least access to someone who did have one of those things. But it would have been difficult to imagine, as Michael said, the massive change that the democratization of access to mass markets, that is the internet, ushered in. But at the same time, we've also seen a massive change in the protection of people's privacies since those years of OPC's infancy. So, of course, this year we celebrated 30 years of that first Privacy Act 1993. But it was now nearly 20 years ago that we had Hosking and Runting, which was the case in which the Court of Appeal first recognised the tort of giving publicity to private facts. And it's now over 10 years ago that we introduced its sibling tort, the tort of intrusion, which protects privacy even when there isn't any publication, if somebody just engages in unwanted watching or listening or intrusion on your personal spaces. In fact, privacy protection has come so far that today I'm going to change the habit of a lifetime. I'm not going to talk about why we should extend it. I'm going to talk about when privacy needs to give way to other interests. So I'm going to ask, when should a person's desire to speak or to know about somebody actually outweigh somebody else's desire to keep information to themselves? And although Sir Bruce's contribution to the law of privacy was within the Privacy Act, I'm going to talk about this question particularly in the context of the tort of giving publicity to private facts. But I do this in the hope that the approach that's taken and some of the principles which I pull out of those cases are relevant or have resonance in a wider context. Okay, so before we get to how to deal with those questions, I want to start off with some law, and this will be a recap to some of you, an introduction to others. So this is the privacy tort, the two main requirements of the New Zealand privacy tort set out in Hosking and Runting, as I said, at the end of 2004. There are two main requirements to the privacy tort. It's nice and simple. Did the claimant have a reasonable expectation of privacy protection in the circumstances in question? So did they have a reasonable expectation of privacy? And would that publicity have been highly offensive to an objective, reasonable person? Basically, the action protects against publication of things which are nobody else's business. So it tends to be things like your sex life, your medical records, the intimacies of your domestic life, visual access to your naked body, the home and other spaces, things which aren't anybody else's business. Now, importantly for today's purposes, since I'm talking about balancing that interest against other things, there's a defence to the action if there's a legitimate public concern in the information in question. So if the public has a legitimate concern in your sex life, your medical records, or the intimacies of your domestic life, then that will outweigh any privacy interest. Now, of course, it's important to mention that the legitimate public concern is not just with what the public is interested about. This is often said when anybody talks about public interest or legitimate public concern. What it's really talking about is things that we should be interested in. So not the private lives of celebrities, although that's what most people are interested in, or a lot of people are interested in. It's actually about things that we need to know in order to be active participants in civic society. So it's a little bit more high-minded than the things that we're interested in. And as already foreshadowed, this talk's going to be partly about when those interests might outweigh somebody's right to privacy. Now, the reason that this is important is kind of obvious, but it's worth stating, and that's that privacy is concerned with preventing the publication of information which is true. So in privacy, I'm not stopping you from publishing information about John Doe's extramarital affair or his mental health struggles because those things did not happen. I'm stopping you from publishing about those things even though those things did happen. So what this means is that when we say somebody can't publish something because it's private, we're stopping them from telling a true story that they want to tell. And we're also stopping people from finding out true information which they might have been interested in. And so when we talk about free speech in the privacy context, we're actually talking about two things. The less important one is generally the actual right to speak. But we're talking about that as the right to express yourself, to share what you want to share with other people. But we're also talking about the audience's legitimate interest in receiving the information. And that's the one that we tend to put the most focus on. That's the one that's the focus of this defence, the legitimate public concern. Now, as is the case, literally every time I stand up to do a talk on privacy, there is a topical example to illustrate the points that I'm making. Every time. Now, just this week, we in Wellington have been asking questions in the media and elsewhere about the privacy rights of our Mayor, Tori Whanau, as she faces rumours that a video taken of her out at a local bar was circulating on social media, although nobody seems to have seen the video. What's interesting about that, though, for my purposes, is that all last week, people were asking if it's legitimate for us to be talking about this, or should we leave her alone when she goes to let off steam in her private time? Now, I'm going to discuss shortly how the courts have answered that question and to give some idea of how they might answer in the future. But when I first conceived of this talk, I actually had a different set of examples in mind, and those are a type of potential private or a type of speech which has been in the public consciousness for a long time. And this is what a phenomenon I'm calling making public allegations. Now, this is most closely linked to the Me Too movement, but what I'm talking about generally is a situation where somebody makes an allegation of harm or impropriety, usually sexual impropriety, against a person occupying a powerful position. Now, this phenomenon, I think, exemplifies the difficult balance that needs to be struck between the ability to speak out about something that's important to you or it's important to society, and somebody's desire to suppress something, because people generally want these allegations to be suppressed. And the tort of privacy has actually found itself oddly in the middle of that debate. I'm going to return to that example shortly, but first let's talk about the politician letting off steam. Because that example, let's say, of a politician drinking too much in public on multiple occasions, it usefully illustrates the first two of three examples that I want to talk about, where freedom of speech interests have been recognised as outweighing privacy interests in the tort of privacy. So here are those two situations. The first is where the disclosure of private information calls into question somebody's fitness for public office. And the second is where the public information corrects a false image being peddled by the claimant. So both of these situations are scenarios where the courts have recognised that the public interest in information might outweigh the right to privacy. So let's have a look at this first one. So the first one, courts have said freedom of expression will outweigh a privacy interest if the private information calls into question the claimant's fitness for some kind of publicly important role. I've said public office there, but actually it's really about, it's a bit wider. It's about a publicly important role. So a good example of this is a case called Lord Brown and Associate Newspapers in the UK. So in that case, the CEO of BP, Beyond Petroleum, I think it means, was held by the English Court of Appeal not to have a privacy interest in respect of information about his romantic partner's misuse of company resources. So the story was that his romantic partner had set up a business running ringtones and that he'd been allowed to use secretarial services of BP. The actual story, that story was actually more of an outing story about him and this relationship. This was kind of a sidebar, but there was enough of a sidebar that the court said that there was a legitimate public interest in it. They suggested that this was suggesting that he was abusing the trust that the company had reposed in him as CEO. Now, this rule that we're allowed to know things about you if you're in a public position applies to all sorts of publicly important positions. So at the top end of the scale are elected officials, particularly important elected officials. So that's the Prime Minister, Leader of the Opposition, Minister of Finance, mayors, but also MPs and councillors who have got less of a high profile. Now, public information about these people, even in some circumstances quite intimate information about health information or similarly intimate things, can be justified if it calls into question their fitness for office. Now, in England, it's also been applied to captains of industry, like the CEO of BP, to football captains, to football managers, and to other professional sports people. The news is getting worse. I'm getting down the list. In New Zealand, one New Zealand case said the executive principal of a high-profile Auckland school had enough of a high profile for this principle to come into effect. In fact, I think this defence is likely or could potentially operate in any situation where the community has an interest and ensuring that a role is being properly carried out by the person who's occupying it. And I fear this might include a lot of people in this room, actually. It's always bad when the private start talking about you. In fact, there was a list in a case called McKinnon and Ash in the UK, where the judge went through and talked about all of the people who were public figures, and it was clergymen and high school teachers and high school principals, I should say, MPs, etc., but notably not judges. But I think it probably does include senior civil servants, judges, high-profile lawyers, probably university professors. So for those of us holding those positions, if something private about us calls into question our ability to do our job appropriately, then it looks like our privacy might be diminished, at least to that extent. Not entirely clear in New Zealand law, that would certainly be the case in English law, although it's always contestable. Now, this right to disseminate information about somebody who may or may not be doing their job inappropriately seems to need to be more clearly related to the job the further down the importance scale you go. So I'd suggest that while it might not be legitimate to publish the fact that an academic has a drinking problem, it might become legitimate if it was shown that I had a drinking problem and I regularly went out and plied 18 and 21-year-olds with alcohol. Because at that point, you might start to say it's interfering with my ability to behave appropriately towards the students that I teach. But at the top end of the importance scale, it's much more permissive. In fact, if you're important enough, it may be that the fact that it shows that you're of bad character or you're reckless or your judgment is bad, that might be enough. 10 points for anybody who is able to work out which public figure this is about. It's undisputed. So this is a case from the UK about a politician. I'll narrow it down. It's undisputed there's a public interest in the professional and private life of the claimant's supposed father. His professional position speaks for itself. As to his private life, he's a man who's achieved a level of notoriety as a result of extramarital adulterous liaisons. Of itself, the fact of an extramarital affair does not render inevitable the publishing of information that, as a result, a child was conceived. However, the claimant is alleged to be the second such child conceived as a result of an extramarital affair of the supposed father. Such information goes to the issue of recklessness, which is relevant both to his public and professional character, private and professional character, particularly his fitness of public office. Any takers? Boris Johnson, yes, absolutely, it's Boris Johnson. At this point, he was the mayor of London. So the moral of this story is if you're a senior politician and you have not just one, but 2 or more love children, then it's probably in the public interest. So he's, but it makes the point quite clearly, right? It makes the point quite clearly that this called into question his fitness for public office, not just his character, not just his electability, but his fitness for public office, because it showed a degree of recklessness that was unbecoming of somebody in that office. So, but it didn't hold him back because he went on to do it. So, but I'm in the third category. I want to be on the second category. So that's the second category. I don't think we can do better than that with that one. The first category, sorry. The second category, I'll go back to that slide. Situations where the information corrects a false image which has been peddled by the plaintiff. The most famous example of this is the leading English authority, which is Naomi Campbell against the Mirror Group newspaper Limited. So this is the case in which the House of Lords held that there was a public interest. The Mirror was entitled to publish the fact that Naomi Campbell was receiving treatment for drug addiction because that had the effect of correcting statements she had expressly made about managing to stay away from drugs, unlike most people in her industry. Everybody agreed, the parties and the judges, that she was entitled to, that the Mirror was entitled to correct that false impression, although they weren't entitled to go on and publish the details of that treatment, nor to dispatch a photographer to take photos of her while receiving it. Now, this category has been applied to the disclosure of the extramarital affairs of public figures in the UK, particularly footballers, if they've put themselves forward as being a reformed character, or if they put themselves forward as being a good family man. So you're allowed to correct the record. It's all about presenting yourself as one thing whilst being another. Now, it's not entirely clear whether these decisions would be followed in New Zealand. We haven't had any cases yet, but I was really interested to see, as the Tory Whānau story played out last week, that the media were relying on this to some extent. They said when after the last incident, when people were calling into question her behaviour in public, she publicly said that she was going to stop drinking in public. They said, perhaps with some grounds, that this put into issue the question of drinking in public, and that the media was therefore entitled to follow up on that and to comment on it. I don't know whether that would stand up in a tort case or not, but there certainly would be some precedent for it. You probably noted that these two categories that I've been talking about tend to involve public figures. They naturally involve public figures. You have to be in some kind of public role in order for your performance in it to be an issue. And you have to, in order to correct a false image about a person, they have to have an image in the first place. So these things are naturally tend to be about public figures. Now, in my view, comments that we often see in the New Zealand case law and in the English case law about public figures having a reduced expectation of privacy or a reduced sphere of privacy need to be read in light of these two observations. Because outside of these two situations, I don't think there's a principled justification for saying that public figures have a reduced expectation of privacy per se. I'm not entitled to know about Chris Luxon's medical records or his drinking habits simply because he's the Prime Minister. What I might be allowed to do, though, is to discuss those things if that calls into question his fitness for public office, or if he's tried to peddle a false image by saying that he's a teetotaler when he's not. Now, it's a fine distinction. I recognise it's a fine distinction because the truth is that that means that public figures have a reduced expectation of privacy. But the point is, I think, an important one, because whilst we need public figures to be accountable for what they do, I think we have to be wary of making an open season on people in public life by saying they have a reduced expectation of privacy per se, particularly if that includes university professors. But this raises a point that's a wider one, which is that it's really important to be precise, I think, about what people can and can't cover in footage, when they're talking about stories about public figures or anybody else. And this brings to bear a wider point, and that's whenever we're balancing privacy and free speech interests, there's a need for certainty and precision in the rules that we're applying. It's important, first of all, that people like Chris Luxon or the All Blacks or whoever know that they retain right to privacy in some circumstances, but perhaps more important is the other side of that coin. Because an individual in a media organisation, if they're going to publish something, they need to, if they want to publish something that the public needs to know, they don't just need to have a defence that protects them, they need to know that they've got a defence that protects them. If the law is uncertain or if it's unclear, they're much more likely to take a defensive position and decline to publish information which the public had a legitimate interest in hearing. As many of you know, this is called the chilling effect. And we used to see it all the time in the beginning of the Privacy Act, actually. You could go to ask somebody to do something and say, oh, I can't do that because of the Privacy Act. I think that stopped a little bit. That seems to happen a little bit less often. No, you don't agree? Still happens. What they mean is, if you ask them which provision, it's always desperately unenlightening. But what they mean is, I'm worried that there might be a privacy issue here, and so I don't want to give you this information just in case there is one. And that's where uncertainty leads you, which is why it's slightly unintuitive, perhaps, though it is, being very clear about the boundaries of the privacy interest and the boundaries of its exception is actually a really important, I think, free speech protection, as well as good practice for other reasons. So those are the first two. Those are the public figure ones. So let's move on to the third category. This is exposing harmful conduct or other serious wrongdoing. And this is moving away from the first example I talked about the politician who was being caught drinking on camera, to the second situation, the making public allegations, the Me Too type situation. Now, the reason here that we can publish this information is because it reveals information that people, the public at large, probably need to know, and that is that this person is engaging in some kind of harmful conduct or other serious wrongdoing. Now, hopefully you won't be surprised to hear there's been a long-standing rule in common law that people can't use breach of confidence and latterly breach of privacy to suppress this kind of information. You can't use those actions, the courts have traditionally said, to hide evidence of your own wrongdoing. Now, in breach of confidence, this has been summed up with the epithet, there's no confidence in an iniquity. And so what that means is you can't go to court and enforce a breach of confidence action in respect of the information about the fact that your alcohol breath tester is faulty, for example, or that you're engaging in price fixing in the laundry industry, or that you were mistreating people under your care in a care home. All of those are examples from the cases where they said there might have been an obligation of confidence, but we're not going to enforce it so that you can keep that information from people who needed to know it. This rule is being carried across into privacy. In fact, in privacy, we often say not just that there's a public interest in this kind of information, but we go one step further and say it's not private in the first place. If you're trying to talk about your own wrongdoing, then the information is not something you have an expectation of privacy in. And this was summarised really nicely in an English case called Brake and Guy last year, English Court of Appeal. Just said, if you know you're doing something wrong, it may be reasonable for you to have an expectation that it may not be reasonable for you to have an expectation that information about that wrongdoing will be kept private. Misconduct is relevant to the question whether a claimant has a reasonable expectation of privacy, as well as to the balancing exercise, in other words, the public interest, if he does. So it says pretty clear authority about the fact that wrongdoing is not going to be private, or if it is private, there's going to be a public interest in respect of it. We've seen this at operation in New Zealand as well. So it helped justify, for example, the disclosure of the fact that the high-profile school principal I was talking about before was being investigated for domestic violence. Said exposing evidence of harmful conduct, therefore, it is in the public interest. Now, there are a couple of things about this rule which I think are important. First of all, something doesn't have to be proven before this rule applies. It applies to evidence of wrongdoing. You don't have to have proved it. So the no confidence in an equity maxim applied as long as there was credible evidence to back up the claim that was being made. None of those claims about the laundry price fixing or the care home abuse were actually proved. And the courts have affirmed this in the privacy context. In that Lord Brown case I mentioned before, there hadn't been an investigation into the misuse of resources, and Lord Brown disputed the fact that the resources had been misused. The court said that didn't matter. It was okay still to say that there was a public interest in the evidence of that wrongdoing. The second point that is important about this is that you're allowed to take the information to the public at large. You might say, well, if you become aware of price fixing and laundry services, you should go to the relevant regulatory body. Likewise, if there's abuse in a care home. But the courts have quite clearly said this is not required. You are welcome to take this information to the public at large. So it's quite a permissive rule. Basically, it says if there's wrongdoing, it's not going to be private. Now, I think this category of public interest is particularly important in the Me Too type situations, which I was talking about, where somebody makes an allegation of sexual harassment or sexual offending against a powerful person, either in the media or online. You might be wondering what privacy's got to do with this, because it would seem initially that the public interest in these cases would be pretty clear cut. I just said that allegations of wrongdoing are not regarded as private in the privacy tort or in breach of confidence. Rather, what we normally do in a situation like that is we leave you to the law of defamation. Say, well, if you haven't done this thing, you can sue in defamation. That's the usual place where we protect reputation. But recent case law has begun to suggest that maybe privacy has a role to play here in keeping the public eye away from allegations that you don't want people to know. And I want to look into that a little bit more with the remainder of the time for this talk. Now, this brings me to the topic which has been engaging courts most actively, both in New Zealand and in England and Wales, in privacy law recently. And that is the question of whether you have a privacy interest in respect of the fact that you're being investigated by the police. Now, in New Zealand, we have two interlocutory decisions on the matter. So the first one is Clegg, which is the principal case I keep talking about, so the school principal case. So this is about the executive principal of Christian School in Auckland. He was denied a privacy injunction, which he sought to suppress information about a police investigation into allegations of domestic violence, which had been made against him. And part of the reason for that, as I've already foreshadowed, was that he played a public role in the community. So no injunction to stop publication of information about the fact you're being investigated by the police for domestic violence. And I should stress that everything I'm talking about at this point is up to the point of charge. Once you're charged, open justice kicks in, and then you're in a different category. But this is up to the point of charge. In contrast, in a case called Driver and RNZ and various other news agencies, the claimant did have a privacy right in respect of information about a police investigation into her conduct. It was called cheating, was the offence, not one we have here, but it was an investigation undertaken by the Indian police. And the New Zealand media got hold of the information about this, including a video of her being arrested, and was giving it some degree of attention. She successfully got an injunction in privacy to say that revealing that information about those investigations was a breach of her reasonable expectation of privacy. Now, the lack of previous public profile was enough to distinguish this from Clegg. So they said in Clegg, they were talking about somebody who had quite an important role in his community. Here, up to this point, she had no public, was not in the public awareness at all. But Justice Clark said she was also open. She was generally open to the idea that privacy can be used to protect reputation in some circumstances, which is a pretty significant thing in my view. Now, there's likely to be a third decision soon. The last time I gave a presentation on this, as I said, that every time I stand up, there's something topical. There was a breach of an order, in fact, that had been made in this case in the Herald at the time. And somebody said to me, oh, you should have a look at this, this article before you give your talk. And I was trying to find it and couldn't get it because the lawyers had got onto it and it had been taken off the online version in the interim. That's how topical it was. I'm very relieved that the Court of Appeal decided not to release that decision today or yesterday, but it will be coming out probably in that pre-Christmas present that they give us on the last day of the year. Anyway, so we've got conflicting authorities in New Zealand. So we don't know at the moment what our position is going to be, whether or not you do have a reasonable expectation of privacy in respect of the fact that you've been investigated by the police. In England and Wales, however, the case law is a lot more settled, at least as of last year. So there's a case there called ZXC and Bloomberg, which is about a man anonymized as ZXC. And if you look, that's right, we're always next to each other. I'm going to talk about BVC in a minute. They're all next to each other on the QWERTY keyboard, these names. But he's a man who had extensive business interests overseas. So a law enforcement body in the UK, we'll call them the police for ease of reference, but they're not actually identified in the judgment. They were investigating him for corruption in that foreign state, and we still don't actually know whether he's going to be found guilty of that corruption or not. As part of that investigation, they sent a thing called a letter of request to the foreign state asking for assistance. Now, that letter was governed by a very confidential regime, which meant that there's no way that it should have been seen by anybody other than the recipients. However, it somehow ended up in Bloomberg's hands, and they published an article based on its contents. And it was clear that that's where the information had come from. That sat on the internet for 18 months before the claimant, Mr. ZXC, got an injunction to get it taken down. So he sued in breach of privacy, saying that because the source of this information was this incredibly confidential letter, I have a reasonable expectation of privacy in respect of it, and it should, and as a result, it should be removed from the internet. Now, I've written about this. There are all sorts of things that I can say about this judgment, including the relationship between breach and privacy and confidence. You're very welcome to ask me about that afterwards. I want to just focus on a couple of aspects of it. Now, all 9 judges, all the way up to the Supreme Court, said that this claim in privacy should succeed, which made me feel a bit lonely because I've been busy writing articles about why it shouldn't succeed and nobody agreed with me. They held that in the usual course of things, a person will have a reasonable expectation of privacy in the fact they're being investigated up to the point of charge. So in the UK, that's the starting point, reasonable expectation of privacy. So in England, if a police officer comes to your house after tonight's lecture and says, can you please accompany me to the police station? I want to investigate your drug dealing. Then you would have a presumption of a right of privacy in respect of that information. So if I went ahead and published it, if we were in England, then I would risk breaching your privacy. Now, there are a few bases on which the courts could have decided to keep that information under wraps. It could have used defamation. It could have used contempt of court. It could have used breach of confidence, but they chose privacy. And in doing this, they made a quite important general statement about privacy, and that is that it's okay for a claimant to use a privacy action to protect their reputation. Now, in saying this, they went against quite a lot of years of contrary High Court authority, usually when the judge in question was a media law specialist, which said that they won't allow you to use the privacy action when what you're trying to do is protect your reputation. Rather, those cases said you had to use your action of defamation. But the Supreme Court in the UK said they're quite happy to say that if something harms your reputation, then that will be taken into account or make it more likely that it's private. So just to really labour this point, if you disclose the fact that I'm a workplace bully, or if they disclose the fact I've got a drinking problem, then the fact that it makes me look bad will weigh in favour of me having a reasonable expectation of privacy. Now, the court put lots of limitations on the way in which this rule played out in the context of police investigations. And in particular, they were at pains to say that the reasonable expectation only relates to the fact and details of the investigation itself. So you remain free to talk about the allegations against me of drug dealing, or you remain free to talk about you remain free to talk about the corruption of ZXC in the foreign state. So the media could write an article about that, it could do an investigative reporting about that. What it couldn't do was draw on material from the police investigation and publish that. Quite a fine distinction. And what do you know? Because it was quite a fine distinction, in almost no time it was ignored. So as a case one particular case I have in mind, and I kind of always have two minds about this case because I think it's really bad, and so I don't want to draw attention to it, but I think it's safe to do so in order to criticise it. It said, so the case is called BVC and EWF. Sorry, I forgot that slide. Oh, I forgot that slide as well. Sorry, I'm too busy talking and not giving you my slides. There are the, if anybody wants the references, I'll come back to that. So this is the BVC and EWF. So in this case, the court said that the reasonable expectation of privacy in ZXC could apply to an allegation of wrongdoing where the information was not about a police investigation at all. In fact, it was just an allegation of sexual offending. And they said, but nonetheless, there was a reasonable expectation of privacy in respect of it. Now, when my colleague at Oxford first sent this to me, I thought this must be a mistake, but here it is in black and white. What the judge said in that case, and what it was about was it was a harassment and privacy injunction arising out of what looked, to be honest, like a vexatious campaign of online harassment of a man by a former boyfriend. And so it looked like there was an axe to grind and looked vexatious, although those issues were never decided. What the judge said was, as I said out here, the defendant's allegations are currently no more than his word against the claimants. They've not been disclosed to the competent authorities, let alone made the subject of investigation by them. It would be remarkable if a claimant accused of wrongdoing by a former lover, with, the claimant would say, a palpable axe to grind, should be in a worse position than a person under proper investigation by an efficient and independent police force or authority. I therefore conclude the claimant's reasonable expectation of privacy extends to those allegations. In other words, the judge is saying, well, if there's a reasonable expectation of privacy when the police have decided there's something to look into, then surely there should be a reasonable expectation of privacy when it's just some guy making things up on the internet. So it's, at first glance, it's kind of appealing, right? It's easy to see why you'd think that, because there's no control there there's no control over whether or not there's anything in this. But the answer to the rhetorical why not question is quite easy to find. First of all, we can have a look for it in ZXC. So in ZXC, the court talked a lot about the particular nature of police investigations. It talked about the relationship of confidentiality that the parties are in and about the dynamics between them when somebody's under investigation. We can question, as I said, I have in other contexts, whether privacy is the right way to protect information about police investigations. But even if you do believe that's the right place, it was pretty clear that it was supposed to be regarded as exceptional, that it was based on the confidentiality of the relationship, it was based on the power dynamics. So it's a bit surprising to see that it's suddenly being extended out away from that situation. And as I already mentioned, the court itself was really adamant that it didn't affect the allegations themselves. You could make the allegation that he was committing fraud in a foreign state, all you liked. You just couldn't report on the investigations. Now, the second answer to why not why shouldn't we protect allegations on the internet, is because the allegations might be true. They might be true. Nobody tested that in BBC. The allegations weren't tested. There was no evidence given. There was no affidavit given about the truth or not. It was not tested because this is a privacy injunction, and in privacy, truth is not an issue. And we've seen that in a case called Richards and BBC, which you might have heard about. Cliff Richard, this involved Cliff Richard being investigated for historic child abuse allegations. And they, did anyone see the footage? They hired a helicopter, the BBC hired a helicopter to look through the window while they were searching his apartment in London. No charges were ever laid against him in connection with that or any other offence. He sued in breach of privacy for that, and there are all sorts of things that went on in that case. But what's interesting about it for this purpose is that he got £210,000 in damages, including for loss of reputation, for the reputational harm that was caused by that coverage. Again, the problem is nobody ever tested the question of whether it was true. Now, I stress, because we're talking about defamation and I'm being recorded, I'm not going to suggest that they were true. I mean, they probably weren't true, but it was never tested. Because privacy is not about truth. Privacy assumes that the information is true. And so we've suddenly got these awards being made on the assumption that information is false in an action which is not about falsity. And in that case, £210,000 worth of damages, a lot of which were for loss of reputation, went Cliff Richard's way. Same thing applies in BBC. The judge had obviously made up his mind it wasn't true. There was a lot to give this impression it wasn't true, but it wasn't tested. And you'll remember that I started off talking about this with all those cases about how wrongdoing, evidence of wrongdoing, isn't private. Evidence of wrongdoing and is also means that there's no confidence, that you can't rely on breach of confidence either. So we've got cases saying that where somebody is giving evidence of wrongdoing, then you can't rely on privacy and you can't rely on breach of confidence. But none of those cases was cited in any of this case law. It wasn't cited in BBC, it wasn't cited in ZXC. In fact, it hasn't been cited in any of the cases that I've seen in police in the police investigation context. In fact, it's been cited by counsel because I know that because I was going on about it so much and had been in touch with them a little bit, but it's never made its way into a judgment. But I think they seem relevant because there seems to be at least some argument that information about police investigation into ZXC's conduct in a foreign state is evidence of wrongdoing. It seems like if the police are investigating me for drug dealing, then perhaps you could say that that provides some kind of evidence of wrongdoing. Now, we might want to accept that, accept as in make an exception for it, but you would have thought that that line of authorities would have been considered somewhere. Now, the reason I think that all this is a bit problematic, I've already hinted at. As I said at the beginning of this talk, privacy in the common law is designed to protect private information from disclosure because it's nobody else's business. It's nobody else's business what's in my medical records. It's nobody else's business what's in my head. It's nobody else's business what's in my private computer records. It's not clear that it's the case. It's not clear that it's nobody else's business if somebody has complained to the police that I've engaged in seriously harmful conduct. It's difficult to say, I think. But I say, well, look, I know I'm being investigated police for sexual assault of my employees, but that's not your concern. There might be other reasons why we want to keep that information out of the public domain, like the reasons about the integrity of the police process, reasons of reputation, but I'm not sure that privacy is the right way of looking at it. Certainly don't think that privacy is the right way of looking at BBC, the situation where somebody's made an allegation on the internet. There are other actions which can protect you against this. And that's the good news, because we do have a tort which is all about suppressing untrue information, and it's the law of defamation. In fact, this tort's been developed over centuries to strike the balance between reputational interests and freedom of expression and the harm caused by falsehoods to a person's standing in the community. Now, it's unsurprising, in light of that focus, that truth is central to the law of defamation. So defence, truth is an absolute defence. There's a rule in Bonnard and Perryman that it's very difficult to get an injunction if the defendant wants to plead truth. We have a public interest journalism, responsible community journalism defence. And we have other things built into defamation to protect free speech, like a 2-year limitation period, as opposed to the 6-year limitation period that operates in the tort of privacy. In England and Wales, it's 1 year. And I think this is actually a source of a lot of the problems, because somebody turns up to their lawyer and their limitation period and defamation has expired, and you say, well, why don't you try this one? And in fact, sometimes they're completely open about the fact they're doing that. That's what happened in a case called Sikri. It also happened in Driver. The defamation action was struck out because it was time barred, and so they moved across to privacy. I want to just pause at this point before I talk about that a little bit more, and I want to note that none of this stuff, none of this truth stuff, will actually prevent you from succeeding in defamation if somebody talks about a police investigation into criminal conduct which you are not guilty of. So you can't satisfy the truth defence by saying, oh, the investigation's taking place. So if I say, look, I'm not a drug dealer, that was a mistake. They say, oh yeah, I know, but you were being investigated by the police for drug dealing, weren't you? That doesn't satisfy the truth defence and defamation. And I think that's quite an important thing to know. If the sting of the original article was that I was guilty of drug dealing, or that there was good reason to suspect that I was guilty of drug dealing, then that's the sting that needs to be met. You're not going to meet that sting by saying, oh yeah, the police did actually investigate. So it's quite that point was not seemed to have been stated differently in Driver. So I think it's a really important thing to know, because then defamation does give you a cause of action here. Now, I mentioned before that, and as I said, in Driver itself, the defamation action had expired, and that's why they switched to privacy. I think this highlights a real danger that in cases like ZXC and Driver are actually being used or could be used to circumvent the free speech protections which have been built into the law of defamation. The common law has been very jealous of those protections for a long time. In fact, some of the judges in the UK are suggesting that there should be a rule that if you're trying to get damages and for reputational harm, you should be required to sue in defamation. But if you don't have to, why would you bother? Why would you bother with all those annoying free speech protections if you can just sue in privacy and avoid them? And you get to avoid difficult questions about truth at the same time. And I'm already hearing reports from barrister contacts in London that genuine public interest reporting is being held up for weeks in legal wrangles about rather generous, shall we say, interpretations of the rule in ZXC. And I'm also wondering what sort of chilling effect this is having on victims. It's not hard to imagine where a junior employee makes a true allegation of sexual harassment against a powerful person whose lawyers then intimidate them with claims about how allegations of that nature are in fact private. And they've got some authority now to back them up. Very surprising if that's not being weaponized already. And I think this brings us back to the point at which I started about the need to balance really carefully privacy and free speech interests as we take these actions forward. Now, in the kinds of situations that we're talking about, there are definitely important interests on both sides of the ledger, and I think we have to look at the interests on both sides of the ledger. Information about police investigations like that disclosed in ZXC and Clegg and Driver can devastate a person's reputation in a way that's hard to solve, to restore. So too, of course, can Me Too allegations. We've seen it time and time again. A lot of organisations will immediately go and dismiss a person when an allegation is made. They don't seem always particularly good at reinstating them if it's found not to be correct, and it's difficult to correct it anyway. Everyone in society loses if false allegations of serious wrongdoing can be made with impunity. So it's easy to see why the judge in BBC wanted to do what he did. It's easy to see why he wanted to stifle what he thought was a false allegation. But on the other side of the coin, it's important to recognise the wider context in which decisions like ZXC and BBC are being made. As is acknowledged in the privacy and no confidence in iniquity cases, it's really important that people can expose wrongdoing, and also that they can expose problems in our systems which enable that wrongdoing, particularly if it becomes a systemic problem, as was claimed in Me Too and a lot of the whistleblowing cases as well. So maybe the allegations are in cases like ZXC and driver need to be considered in this wider context. In particular, I think it's really important in New Zealand, and I hope that it'll be interesting to see what this Court of Appeal case says, but I think we really need to be alive to the risk that using privacy to protect against disclosure of the police investigations can lead to people trying to suppress allegations of wrongdoing, as we've seen in this case here. It seems clear to me that our response to this problem, the response to the making public allegations, needs to try to maximise the successful making of true allegations and minimise the making of false ones. Privacy, whilst as Sir Bruce Slane knew is important for many things, is not designed to do that. Rather, privacy is designed to let you keep to yourself things which are nobody else's business, even if they are true. That's the end. I agreed to take questions and I had no idea how long that took. So are you happy, Michael, if I take questions or just for 5 minutes? Yeah. And somebody's going to be the runner. If you don't want to ask a question, you have to. Can be the runner. Are you going to do the? Stephen. Stephen and I talk about this all the time, so I'm a bit worried about what you're going to ask me.
I'm just wondering, I mean, you said, I think rightly, that when you're exposing harmful conduct and other serious wrongdoing, that's going to be relevant to reasonable expectation of privacy and potentially legitimate public concern. I'm wondering how non-disclosure agreements play into that.
Yes, that's a really good question. So the question for people on, you probably heard it because it was Mike, but so how do non-disclosure agreements play into whether or not you have a reasonable expectation of privacy? Yeah, I mean, this is my argument in all of this is that privacy and confidence need to be separated. And so a non-disclosure agreement creates an obligation of confidence because you agree that you're not going to disclose the information in return for some kind of consideration, usually. Now, we had that relationship at play in ZXC as well. We had a situation where the letter of request was confidential, but it was confidential because of the relationship between the state that they were asking for help from and the police. It wasn't confidential because they were trying to protect the person who was being investigated. So I think that we need to say that in that situation, I realize it's different, we need to separate out the question of confidence and the question of privacy. And I think there's probably an argument that we should do the same thing in non-disclosure agreements, because how would the argument go? You'd say, I've signed a non-disclosure agreement with you that you won't disclose these allegations of sexual harassment, and now that means that I've got an expectation that that will remain private. It's probably right, as a matter of fact, right? But I think that when we talk about reasonable expectation of privacy, it's actually asking a slightly different question. It's not just saying, as a matter of fact, is this information which is being suppressed? Rather, it's saying, is this information which is nobody else's business? And I think if I've signed an NDA, the information that you're sexually harassing me is still somebody else's business. There's also the question, I don't understand, the people here who practice in this might know more than me, but why is the no confidence in iniquity does not apply to those situations? Because I have seen it applied in situations, because where there's a contractual breach of confidence there, and that tends to be the strongest. But I have seen the no confidence in an iniquity be applied to contractual situations. Why do you not just breach it and say, sue me? No, it's an iniquity. But it tends to be that people want these things to go away and haven't tested it. It's a great question. And I think it's one of the things that I find really fascinating about this topic is that it's the intersection of all sorts of different things. We've got breach of confidence going on, we've got defamation going on, and then we've got this kind of new upstart which is coming in, which is the law of privacy. And I think it's really important that the law takes its place in a way that doesn't start to encroach on other things. But the minute you have an action which is a bit amorphous, which is kind of new, then you start getting people trying to push into these other areas. And I think we need to be really careful about saying, well, actually, no, this is its domain, and not to let the two bleed over, or the three bleed over into each other too much.
Hi. So this was all really interesting from a court perspective. I was wondering what your views were on situations before it gets to the court situation, because I understand that for a lot of people, access to lawyers and justice is it's just a question of cost. And I was wondering how this would play into before, like in everyday conversation.
That's a really good question. I mean, I specialize in celebrity law, because rich people have human rights too. It's no, but really, it is a serious thing. I mean, if you look at the claimants in the privacy cases in the UK in particular, it is all billionaires and celebrities. And most of the cases, they're trying to keep their extramarital affairs from their wives. So literally, that's 90% of the case law. So the question is, what good does this do to everyday people? And the argument that I have used to justify myself in specialising in this area is that they develop the law, and if it's clear enough, then hopefully it filters down into the treatment of everyday people, certainly by the mainstream media. I think we have seen a change in the behaviour of the mainstream media in response to these cases in the UK at least, and maybe here as well. And I hear, actually I was watching a documentary about David Beckham recently, and there was a paparazzo on that who said that we wouldn't behave like that anymore, right? So he was talking about his kids. I mean, he's a celebrity, but it's so I think that's the hope, is that you set up the law and the principles kind of filter down into the behaviour of the defendants, not just when they're dealing with celebrities, but when they're dealing with everyday people as well. That said, I think in New Zealand, our particular flavour of privacy breach did not involve celebrities. We've always been quite good at that kind of thing about public figures, but we've been bad traditionally at chasing people who've suffered trauma or been in an accident, taking photographs of them and putting it in the media. I sometimes worry that that's done partly because those people are not as well resourced when it comes to litigation. And it's a really serious question to ask about what do we do to make sure that those kind of people are protected. That's where I send them to the Office of the Privacy Commissioner, the Broadcasting Standards Authority. But it's a really legitimate question. I mean, nobody can afford to bring an action unless they're J.K. Rowling or a Russian billionaire.
Thank you. Hi there. I just had a question I'm just interested in your thoughts around the privacy rights of children, minor children. So not in the celebrity hosking sense, so not the media taking photo of children, but people who post photos of their own children, on social media. I mean, lots of people do it. You've kind of got a spectrum. You've got, I post photos of my daughter, but my account's private and only my friends see it. The other end of the spectrum is, mumfluencers, posting photos of their children to big audiences. What do you sort of foresee coming with that?
It's sharent, isn't it? Isn't that the comment? Sharenting. It's a really good question, and it's one that the courts have had to deal with in situations where the media are going after the kids. It's the same issue though, because they say, where's the line between the parent and the child? So if you have a child who's being paraded about on the red carpet, who's been put in Hello magazine and celebrity photographs, is there a point at which that actually affects that child's private life because the parents have chosen a life for them that even though they didn't have any choice about it? Now the courts try and strike a bit of a balance. They tend to say we recognise that the child will have a privacy right that is separate to the parents, but there is a point at which you just have to defer to what many people would think is bad parenting. So it's an area really where I guess we get that in everything, don't we? In family law, like at what point do you allow parenting to be bad, and at what point do you step in? So there was an urban myth for a while that somebody in Germany had sued her mother. Did anyone see that story? Turned out it was fake news, really good fake news. I had gotten all the media, but I had it on good authority that was incorrect. But you can see, but you do sometimes talk to young adults who really don't like the fact that their parents behaved in that way. And so I think there's more awareness of it, but it is a very tricky question about where that line, how do you protect the child without interfering with the autonomy of their parent? And the courts they've said we'll do it a bit, but not to the extent that we force good parenting in inverted commas on the sharent. There we go.
Thank you.
Nicole, thank you so much for what we knew and what was a insightful, thought-provoking presentation. It, I think, reminded us all that this issue of privacy, of rights, of law, of values is something that it's worth debating, discussing, and really pressing into, both as individuals from our own perspective, but also as a nation going forward. So thank you again. Thank you everyone for joining us for this year's Sir Bruce Slane Memorial.